Hello, my name is Afifa binti Muhammad Sharif 264805. Here I will give you a brief introduction regarding our case review re-Derby. Separate legal entity is one of the fundamental concepts under the Malaysian company law. It is defined as a person recognized by law. Under Section 20, Subsection 1, Companies Act 2016, a company will become a corporate body which has separate legal personality from its member. It means the company will become a body corporate that exists separately from its owner. In other words, the company is an entity which, like human being, created using legal and official purpose. With this principle, a company will be treated as a person who has the legal rights and obligation, which also has the ability to enforce its rights and obligation. Under this concept, corporate will principle exists between the owner and the company. There are a few characteristics under this concept. Once the company relies on this separate legal entity concept, it has unlimited capacity to enter into transaction. Since a company is regarded as a separate legal entity, thus it is liable to the debts of its owns. Therefore, the creditors are prevented from claiming their rights directly from the shareholders. Next, it can sue or be sued in its own name. The company has the ability to take legal action without using the owner's name. Other than that, it also has the ability to acquire the own property in its own name. The company may develop or dispose the property without interference from its members. The property will be registered under the company's name. The member have no legal or equitable right over the property. Lastly, the company has perpetual succession. It means the company will continue to exist even if there are changes to its membership. This requirement has been provided under Section 20, Subsection 2 of Companies Act 2000.
Hi, my name is Nur Shazrina binti Yaakob and my matrix number is 264562. And today, right now, I will briefly explain the grounds of appeal or the legal issues that have been arise in this case. So basically, this case was an appeal case as the appellant argued on the judgment made by the lower court. First of all, the appellant contended that the debtor was not a promoter, and if he was, there is no legal liability on his part in respect of any part of the claim was disclosed. And secondly, the second contention is on the legality of the claim, as its nature are not provable. And all of these crises arose as the action of the respondent did not parallel with the agreement.
Assalamualaikum. My name is Emilia Afrina binti Nurazi. My matric number is 265008. I will be explaining on the facts of the case. This case is regarding a court ignoring the veil of incorporation where an incorporation is used to conceal a fraudulent operation. The fact of this case is that Darby and Guy were undischarged bankrupt and in the same time were fraudsters. A corporation called City of London Investments Corporation Limited, which comprised only 7 signatories to its Memorandum of Association, was formed in order to shroud their identity in carrying their financial operation. Darby and Guy were the sole directors and also managers of the corporation, and they are entitled to all profit gained under this corporation. The corporation intended to register and scheme a company in England named Wells Slate Quarries Limited for £30,000. The corporation at that point contracted to purchase license to work a quarry for a small amount. A contract was entered by a trustee named Marcus, a trustee on behalf of the company, whereby the corporation as the vendor agreed to sell the license and plant for £18,000 to WSQ. They then formed a company named Wells Slate Quarries Limited and discovered 7 signatories to its Memorandum Association and also its directors. Darby and Guide arranged prospectuses to invite public to take debentures in the company. The company financing to make this acquisition came from the sales of the debenture to subscribers who had been convinced to take an interest in the strength of LIC representation. The contracts and prospectuses disclosed that LIC was both the promoter and also vendor and was making the profit despite the fact it is actually Darby and Guide were the actual promoters and vendor, and in the same time receiving the profit through the corporation. Unfortunately, WSQ failed and went into liquidation once the subscribed fund had been paid over to LIC. Subsequently, Darby and also Guy were indicted for fraud and both become bankrupt. The liquidator claimed for Darby's secret profit which he made as a promoter. However, Darby objected that he was not the promoter, but LIC was the promoter. The official receiver, Mr. Botham, had up a proof in Darby bankruptcy for £8,950. The trustee then dismissed the evidence since Mr. Darby was not the promoter, the corporation was the promoter.
Assalamualaikum and good morning. I'm back to Madam Hayati. I am Muhammad Nabil Aiman bin Muhammad Nasir, matric number 265028. So I will explain on analysis of principle of law. So in this case, basically there are two principles of law applied. The first one is separate legal entity and the second one is lifting the corporate veil. So we move on to the first part, which is separate legal entity. So it is a principle where it stated that a company established should exist as legal entity upon its registration. This means that once the company has been registered, it should be capable to have its own right and obligation. Thus, any action made toward or by the company cannot bind the members of the company. So, the members of the company, which may consist of the shareholder, director, or the main controller, cannot be treated together with the company. So, this principle derives its authority from the case of Solomon against Solomon and Company Limited, where it stated that a person, even as a majority shareholder or the main controller of the company, cannot be treated as the same entity with the company because the rule of separate legal entity will be applied. So, we look into the case of Radabi. In this case, however, the rule of separate legal entity did not apply. Why? It is because there exists some exceptional situation which lead to the application of lifting the corporate veil. So what is the principle of lifting the corporate veil? First, I will define corporate veil. Corporate veil is a situation where it will stop any parties or the court especially from taking any action on the members of the company due to principle of separate legal entity. So the company and the person behind the company or the members of the company will be treated separately. So it means that the court can approach the member of the company upon any obligation of the company, or in this situation we use the term the court cannot look behind the veil. However, it is not an absolute situation because there are some situations where the veil can be lifted when certain situations occur. So among the situations that allow the corporate veil being lifted is when the corporate form had been used to evade the law or to achieve an unfair result. And the second one, when a person is under existing legal obligation or under legal restriction. Thus, in order for him to try to evade or frustrate the legal obligation, he had manipulated the company under his control. So basically, there are a few grounds to lifting the corporate veil. However, in this case of Radabi, only one ground had been used. So the ground is the corporate form used as a facade to avoid an existing legality or to commit fraud. So it is a situation when a person had manipulated or used the company in order for him to avoid any legal obligation that independently imposed upon him, or in order for him to gain any personal advantage by unfair means. Thus, he will then rely on the principle of separate legal entity in order for him to frustrate the enforcement of such obligation or escape liability from his action. So, put it in simple words, it means that the person try to put the blame on the company by hide behind the name of the company, so he will escape any obligation that basically should be imposed upon him. So, in order to lifting the corporate veil, there are two elements need to be proved. The first one is a person must capable to control the company. The second one is the company being used by the person to circumvent the law. So, these two conditions are related to each other. So, when the corporate veil had been lifted, there are two effects. The first one is the members of the company who hide behind the name of the company will be made personally liable for debts and liability, and the second one is the liability of company will be treated as liability of the person controlling the company. This means that the company and the members of the company will be treated as the same legal entity. So when a person uses the corporate form as a facade or to commit fraud, there are a few concepts can be used, and one of it is concept of holding and subsidiaries company. So it is a concept when a person uses the holding company and the subsidiaries company in order for him to commit the fraud. So in general rule, the holding company actually entitled to incorporate subsidiaries company if the main purpose is to minimize the business risk. In this situation, the principle of separate legal entity will be applied, which means that holding company one entity and the subsidiaries company is another different entity. However, if the situation show that the holding company and subsidiary company had been used in order to commit a fraud or as instrument of a fraud, the corporate veil, however, will be lifted in this situation. So we look into the case of Reda B. So in this case, they had been used the concept of holding and subsidiaries company, where actually promoters, Mr. Darby and Mr. Guy, had used holding company as a mask and make a fraudulent statement in prospectus promoting the subsidiary company. The promoters had using the name of holding company and concealed the real fact that they were the real promoters that enjoyed all the profits, not the holding company. So the holding company had been used to avoid liabilities or claims made. Thus, it fall under fraudulent act which caused the corporate veil being lifted. So Mr. Guy and Darby are liable in this case. So I done explain all the principles that be applied in case of Reda B. So next we can move to the Malaysia perspective. So I will explain on the Malaysia perspective on the issue of fraudulent in corporate law. So Malaysia also concerned on the issue of fraudulent in corporate law. So we also have the few provisions that govern on this issue, and we also has a case that related on this issue. So the provision related on this issue is the section 540 of Companies Act 2016, where it stated that a corporate veil can be lifted if found out that company had been used to carry out business with intention to make a fraudulent act or purpose. Thus, it can cause the person controlling the company will be personally responsible for all the debts and responsibility of the company. And in case, we have a case of Chow Siang Jin against Lau Chai Ching, where in this case, the deceased had transferred all his property to the defendant, which is his son. In later time, his another children, which is also the plaintiff in this case, had claimed the right to the property that had been transferred earlier. However, the defendant had claimed that the said property had been transferred to the new company, so the deceased or the defendant had no longer had any right to the property. However, the real fact is the new company actually also owned by the defendant, so he controlled all or the most of transactions made by the new company. So in this case, the court held that the court agreed to lift the corporate veil and make the defendant liable for the claim made. Why? This is because the new company had been used as a mask for the purpose of defeating the plaintiff claim on the deceased properties. So this means that the defendant had honestly or had caused a fraud by using the new company in order to defeat the claim made by his sibling or the plaintiff. So that's all for the analysis part.